Now, business people are going to be very interested in whether or not a contract has come to an end, whether or not it's terminated. There's a few reasons for this. First, it's prudent for business people to know or to want to know when their obligations have been satisfactorily performed under a contract, when they are no longer obligated. This is no longer on the books. Secondly, they're going to want to know when the other contracting party has fulfilled their end of the obligation and they can no longer expect anything else, any other consideration to flow from the other side. It is very important for the parties to know this, to know exactly where they stand with respect to what they could potentially still be liable for. Now, contracts can terminate in various ways. And the reason that I did this video separately is I wanted to give you kind of a big global understanding of how contracts can come to an end before we get into the details of each individual heading. So there are various ways in which a contract can come to an end. The vast majority of contracts come to an end when both sides perform their obligations. Simple as that. The parties have entered into a contract. A decides to give B, C decides to give D. They both give what they said they were going to give, and the contract is done. That is a situation where the contract is terminated by performance or by paying money, which we're going to go into detail in another video. It's also possible, if there are unforeseen circumstances, that a contract can come to end by the creation of another agreement. Perhaps the circumstances surrounding the contract no longer apply and the parties find themselves wanting to do something else. Maybe instead of having a pool, they want to have a shed. We will talk about those circumstances, but they're quite common in the business world as well, where business people, very realistic and practical, realize that a contract can't be performed or it's no longer going to fulfill what they want. So they go to the other side and say, hey, can we come up with a different agreement? These are also very common. I won't go into detail, but there are circumstances in which a contract will come to an end by operation of law. One of the common examples of this is bankruptcy. I will, however, go into a lot of detail regarding contracts that have been discharged or terminated due to a breach of contract. This is a circumstance when a party fails to fulfill its obligations. We're going to be focusing on what options an innocent party has available to them when the other party does fail to fulfill its promises. Finally, of course, there's the remedy of rescission, which we have talked about in multiple videos and in previous chapters, and don't need to go into detail again.